Oyez, oyez, oyez. Anyone having business for the King's Justice of the Superior Court of Justice, attend now and you shall be heard. Long live the King. The Honorable Justice Hennessy presiding. Please be seated.
Good morning, all. Ms. McNamara.
Good morning, Your Honor. May I begin?
Please do.
Thank you. So I would like to start today by turning back to the question you asked me at the end of yesterday. And I want to turn to your question in two parts. So first, Your Honor described that there was a time where rivers were needed to travel, or that we needed to be face to face in order to communicate, and that now we use radio waves for that. And second, Your Honor requested an explanation about connecting the dots, I think were the words, in the differences between spectrum and other resources to the issue of whether spectrum is sufficiently connected to the land or water to be included in consideration. So I want to start by turning back to the treaty promise, which was to augment the annuities if the territory ceded shall produce an amount which would enable an increase. So we know that the revenues need to arise in a closely related way to the use, sale, or licensing of land, including water. And I want to be clear that when Canada submits revenues from spectrum regulation are not and should not be captured by the definition of relevant revenues because they're not produced by the territory, that does not mean that the Anishinaabe should not participate in the benefits from the use of spectrum. And of course, we know they do participate. Spectrum waves can and are used in Anishinaabe communities. So issues related to usage in terms of allocation and access, those can be resolved by policy decisions, and that's a separate issue. Access to spectrum does not mean that spectrum revenues form a part of the treaty promise, because the revenues are not proceeds from the treaty territory. And I know that's the second part of the question is, well, it sounds to Your Honor as if they are related to that territory. And we're going to get to that in a moment, because I want to again state that whether we're talking about past use of the land or future use, any use, it does not matter, because no use of the land is closely related to how federal spectrum revenues are generated. And so this brings us to the second point, and I think that's a great way to summarize what we discussed yesterday. The differences you've heard about spectrum, they aren't just unique characteristics that make spectrum special. They are characteristics that demonstrate radio waves are not closely or directly related to the land, and that revenues from spectrum are not analogous to mineral or lumbering revenues. And I'll explain how. When we say that spectrum is continuous and has no geographic boundaries, we are explaining that land boundaries do not impact spectrum because it does not exist on the land or in relation to the land. It exists in the airwaves. If you recall, all of the waves, including radio waves, on the electromagnetic spectrum are actually types of light. And so while the sun may shine upon the ground, you wouldn't say that that sunlight is closely or directly related to that land. Some satellite signals pass through international outer space, and others bounce off the Earth's ionosphere beyond the Earth's atmosphere. And that comes from the Harvey Levin, Levin article. And I'll give you the tab for that again, just so no one has to go back searching. That article is fully reproduced in Exhibit I, which is Canada's compendium for cross-examination of Mr. Hutchings at tab 9. And that reference comes specifically from page 448. And to be very specific, when I say that these waves bounce off the Earth's ionosphere, the ionosphere is between 80 to 1,000 kilometers above the surface of the Earth. And these waves go beyond the Earth's atmosphere entirely throughout space. Now, you can't impose or force geographic boundaries on spectrum either. ISED does draw up blocks of spectrum over certain areas for the coordination of licenses, but those boundaries are not inherent to spectrum as a resource itself. And every resource in this case that's relevant has geographic boundaries because it is a part of the land. At some point, a forest ends, a mineral deposit doesn't cover the entire ground underneath Thunder Bay. It has limits. A continent ends, a lake ends. The unique properties of spectrum pollution also provide evidence that spectrum is not related to the land. Because if spectrum had a relationship to the land, closely, directly, or even a distant relationship, the pollution of one would affect the other, and it does not. And the last characteristic that we talked about or started to was spectrum being considered as common property. And I didn't really have a chance yesterday to get into what I'm going to say here next, but we'll be talking about that today. And so the reason why spectrum being considered common property distinguishes it from the land is because the common property nature is reflective of spectrum being continuous and having international character. You can broadcast from one continent to another, across the ocean. These radio waves do not respect artificially made human boundaries. They don't care where your land ends, where your property ends, or even where the Earth ends, because they don't exist in relation to the land. And that idea that spectrum is common property is important because that's why there is no ownership and no property rights to spectrum. The federal government does not own spectrum. It merely manages spectrum licenses within Canada pursuant to international agreement, which is necessary to ensure that spectrum is usable for Canadians. Without international cooperation, and I'll be talking more about this when we discuss regulation, it's actually likely that spectrum would be polluted to the point it would be completely unusable for anyone. So when we think of the treaty, and when we think about the Anishinaabe giving up control over the land, the territory, by way of the treaty, the Anishinaabe were not giving up ownership to airwaves hundreds, if not thousands of kilometers above the territory. And in turn, because there was no ownership there, the federal government did not inherit ownership through the treaty. Instead, the federal government just manages spectrum licenses because international cooperation is required for spectrum to be usable. So turning back to where we left off in my roadmap, we're going to talk about the last point on spectrum's nature, which is that common property element we've briefly touched on. And then we're going to cover the final topic of how spectrum is regulated and how that regulation generates value. And so this is where I made my bad pun about the deep end. And thank you, Your Honor. I want to explain that there's significant nuance beyond my friend's statement that water is not subject to ownership. And it's really beyond the scope of this case to get into the nuances of water law, but I do want to make a few points in order to respond to that submission. First, water and spectrum, even if you conceive of them both as common property, they're not common property for the same reasons or in the same way. Mr. Schachter acknowledged that Ontario has appropriated water power onto itself, notwithstanding riparian rights. And as we may be aware, riparian rights are actually tied to land ownership. It is the owner of land that abuts a lake who possesses rights as an incident of ownership of that land. And the genesis of these riparian rights come from the historical need for navigation across water. And I say this in part to respond to the submission that water or water ownership and rights are not linked to the land at all, because that's exactly how we conceive of them, is in relation to the land. And there's no similar carve out that owners of land possess rights similar to riparian ones as an incident of ownership of that land. And the second point is that water law actually shows us in many ways how water is a part of the land or linked to the land. It reflects, and we know, bodies of water take on different forms and that different rules may apply to these different bodies. We also know that bodies of water can change. Floods and droughts happen naturally or by purposeful human action. And water can take over more land or expose the land underneath. And there can be different rights associated with those accretions, erosions, or floods. And so in the recent case of Chippewas of Nawash Unceded First Nation, which is the 2023 Ontario Court of Appeal case, the court was discussing the concept of title to submerged lands. And they stated at paragraph 94 that the common law has permitted private ownership of discrete areas of property on the seabed or lake bed. And to clarify, that's not just the shore, that's actually the land underneath the water. And because it is linked to the land, because water is a part of the land, it is often also used as a boundary for plots of land, whether on surveys or things of that nature. And in fact, the water is used as a description of the Chief Points Reserve in Treaty 72. And that's, although it's the same treaty, it is from a different case. That's from Chippewas of Saugeen First Nation, which was also this year, but the Ontario Superior Court. And so while, sure, some bodies of water, some parts of it may be subject to common ownership, it's not the same as why spectrum is treated that way. Spectrum is considered to be common property because the waves cross borders, cross boundaries internationally across the whole world, and it requires international cooperation in order for anyone to use it and to get value from it. And that brings us to the last point that I want to make, and that's about the topic of regulation. And we're going to keep talking about water because I think it really does provide kind of the best comparison to highlight those differences and show why spectrum should not be captured by the judgment. So, under the topic of regulation, you can find our written submissions on this point, mainly at paragraph 152, but also 150 and 153. Canada submits that the value of a spectrum license comes from the customer base, not the land, because of the way that spectrum is regulated. And it is these regulations that give the license its value. And at paragraph 152, we explain why the value comes from the customer base. And rather than repeat what's in our written submissions, I want to focus on 2 points that arise in response to my friend, Mr. Schechter. The first is what a license does and does not do. And the second is what I'm going to call the private ownership problem, or the value of spectrum and this idea of private landowners. So a spectrum license does not convey property rights, whether to spectrum or to land. And while my friends paraphrased both orally and in writing at paragraph 463 of their submissions, that the Radio Communications Act paraphrase the Radio Communications Act to say that a spectrum license provides a right, nowhere in the act is this word used. The minister has no authority to sell or otherwise convey ownership of spectrum or of land. And if a license holder needs to build some sort of physical structure on the ground, and that if is important because we know that ground infrastructure is not always required, the relevant statutory powers, which we've listed for you at paragraph 150 of our written submissions, those statutory powers do not supersede the need for a license holder to come to individual agreement with a local landowner. The license holder has to enter into your typical commercial agreement if access to someone's land is going to be required. The spectrum license and its revenues and the federal government have nothing to do with the agreements or negotiations regarding use of that land. With respect, Mr. Hutchings, as illustrated by his graphic that was introduced in his demonstrative, this is the graphic, it's in Exhibit 11, page 93. It was a picture of the map with all the little red dots that you might recall. We discussed this graphic and its flaws at paragraph 158 of our submissions. But I think it's important to bring back up because it shows that Mr. Hutchings did not seem to properly understand what a license does and does not do, and the rules that are in place on a license holder. And this is because Mr. Hutchings was unaware that sharing existing structures must be considered first before new physical ground infrastructure could be considered. And you can read this exchange in the transcript from February 22nd, which is the cross-examination of Mr. Hutchings. And it begins on page 1753 and continues on to page 1757. Mr. Hutchings also appeared unaware that antenna towers, those physical ground-based infrastructure, are not inherent to the use of spectrum. And you can see this directly in the Professor Stiglitz and Mr. Hutchings expert report at paragraph 138, and the comments he made when giving his evidence, where he claimed that spectrum rights are tied to ownership of the land because use of spectrum requires one to build towers. And now I'm going to talk about what I call the private problem. The plaintiffs suggest at paragraphs 471 to 474 of their written submissions that absent government regulation, a private landowner would be free to contract with individuals regarding the use of spectrum and therefore earn the associated revenues. Respectfully, that misunderstands the nature of spectrum. Because without federal regulation, spectrum would become congested and unusable. It would become polluted to the point where no one would be able to use it or benefit from any of its revenues. And this actually comes from not just my response to the hypothetical, but it is in the evidence. And I will show you where in a moment. I want to play out the hypothetical that the plaintiffs have suggested here. So let's pretend that the Crown's regulation has been abandoned, whether to all of Canada or just to the territory, it doesn't matter. And let's say as a result, a telecommunications company, perhaps Bell, would have to approach landowners not only for the same thing they do today, which is building permissions, but to actually ask whether they're for permission for their spectrum to traverse over the landlord's land unimpeded. Putting aside the bigger fact, or putting aside, sorry, the fact that this company, Bell or whomever, would need to contract with every single landowner in that area, there's a bigger problem. The bigger problem is that even if we had traditional property rights to spectrum in this hypothetical, where spectrum in the airspace above your land was considered to be owned by you, the private landowner does not actually have control over those airwaves or that spectrum. The private owner would have to control interference between any other operators they entered into a contract with. But more importantly, these private landowners would have no way to protect the spectrum waves under these agreements in the airspace from interference coming from outside their land, outside their lot, and outside their jurisdiction. Spectrum waves travel in all directions. From a transmitter, I can't choose to have my spectrum wave travel in a direct path from me up to you, Your Honor. And instead, you can think of it from similar to light from the sun or a light bulb, that it's omnidirectional. And I want to be clear that this example, I'm not suggesting other broadcasters would attempt to be malicious or purposefully jam the signals over your land. It's really just a part of the continuous nature of these waves. You can't saw off a portion of the waves above your land and make them separate from the other waves that are in the airspace. We've already heard that these energy waves don't respect man-made boundaries. So it's not the case, as the plaintiffs submit, that the value of spectrum comes from control over a territory, this specific territory, or any geographic region, because one does not need control over your geographic region to send a signal over it or to interfere with signals flowing from it. And in this hypothetical, it's perhaps guaranteed, if not highly likely, that the interference between these signals would degrade the usability of spectrum completely to the point where it would have no value. These contracts or agreements would be meaningless because it would not be usable for anyone. And again, these difficulties about spectrum's continuous nature and international character are exactly what led us to a system of international cooperation in the first place. And so now, to give you something more solid to ground yourself in, parts of this problem and the economic theory and impacts are explained in the Levin article, which is Harvey Levin, and that's the one at Exhibit I, tab 9. And I'll point to specific pages as we go. Harvey Levin explains that in the absence of international agreements and public regulation or a system of developed private property rights, from an economic perspective, it would be to no one's advantage to refrain from congestion. No user, whether in the same area or a different country, would avoid interfering with another's frequencies. And that's at that's at page 457. And in response to this, perhaps the plaintiffs would suggest that the solution is to now, recognize some sort of private property rights to spectrum. Levin has an answer for this as well. He explains two main reasons why these property rights do not exist today. And this is on page 457. The first reason why these property rights do not exist is that the cost of defending them would be so high or the expected return so low. And the second is that the historical national traditions and international traditions that have operated in the absence of such a scheme. He says that today, there seems little likelihood private property rights in spectrum could ever be tolerated, even if they could be reconciled with the need for international management. And that's on page 457. The validity of a system of private property rights and the existence of them would actually constitute a barrier to any market allocation of spectrum. And that's at page 458. And what that means is that a system of private property rights would be a barrier to having companies or individuals agree to not compete.
We're going a bit far afield, aren't we, on the need, on how far you have to go to argue this point?
Sure. I will move on from it then. In sum, the point is that we don't have these private property rights, and the plaintiff's academic articles state that such a scheme could never be developed in the first place.
Thank you.
And so Mr. Hutchings, he makes a mistake in the same vein when he states that the government should probably control property rights because it's a natural resource. And that's from the February 13th transcript at page 983, lines 12 to 22. And ignoring what we've already talked about here about property rights, we also know that the government does not regulate spectrum just because it's a natural resource. And in fact, it's not regulated by the typical government department for natural resources. It's under Industry Canada. And the government regulates spectrum, not just because it's a resource, but because international cooperation and coordination is required for it to be usable. Mr. Hutchings stated that spectrum has value and someone should be collecting that value. That was on February 22nd on pages 1773 to 1774 of the transcript. And this brings us to the plaintiff's comparison or example of a hypothetical hydro regime. And that can be found on paragraph 474 of their written submissions. And my friend, Mr. Schachter, also spoke about it in oral submissions. Without repeating the whole analogy, the idea is that one would not argue a hydro regulatory regime created those rents because they were there all along to be captured, and they were being captured by others. And that comes from the September 13th transcript at page 81. But the fact is, without the regulatory regime, it is likely there would be no capture of spectrum by others. Without national and international cooperation, private landowners would still not be able to capture spectrum rents. And Levin on page 437 explains that physical availability of spectrum in the airwaves does not mean technical usability. And technical usability does not mean economic usability. And economic usability does not mean effective usability. So without the regulations, though spectrum would continue to exist physically in the air, it is likely that no one would be capturing its value. And therefore, it would not have the same technical usability or economic usability. And in this way, the spectrum regulations are different from hydro regulations because they do create value, or at least preserve value in that way, contrary to paragraph 457 of the plaintiff's submissions. And I'm almost finished here. The plaintiffs proposed clarification to the judgment to add airspace into that closed bracket portion that currently just says, which could include the waters, and to add spectrum revenues. Suggests that airspace and spectrum revenues were part of the treaty territory. It suggests that that airspace was subject to title and ownership before it was surrendered. And their submission that without the treaty, the Anishinaabe would be the ones to control and benefit from spectrum exclusively. That comes from paragraph 457 of their written submissions, does the same thing. Adding this language would dramatically expand the judgment and ignore how airspace has been treated at common law, the nature of radio frequency spectrum, and the need for international coordination. While the nature of spectrum and what a spectrum license entails may have been muddled at times, I think one thing is quite clear. Spectrum is unique from other resources. And these aren't just my words, but the words of the academics. Levin on page 433 explains that spectrum is uniquely free from depletion. Patrick Ryan's article, which is tab 1382, notes the special features of spectrum. And to use the words from Herder's article at tab 1381, spectrum is a very different natural resource. When we use spectrum, we do not take something from the land. We do not extract something. We do not need control over a geographic area to use spectrum or necessarily transmit a signal. And private owners would not capture the same value for spectrum. For these reasons, spectrum does not fit within the judgment or the reasoning behind the treaty promise. And subject to any questions, that concludes our submissions on spectrum.
Thank you very much.
Justice Hennessy, we're going to switch gears to the present value arguments.
It occurs to me that you need to know how long you have before you start. What was the upshot of yesterday, or what was the original plan that Canada went to? How long? To midday today? I can't recall what you were asking yesterday.
Yeah, our expectation is that we will be done before the end of the day.
And was that the original plan?
When you say original, I'll tell you, when back in May, when we first scheduled these 12 days,
Yes.
the expectation was that Canada would be finished midday on Wednesday today.
Right.
And I think we'll probably be able to meet that. We might go till after lunch to the midday break. But I do think that we'll have time to hear from Mr. Greenberg today, and it's possible Ontario may be able to begin as well. The only things I have to cover are present value and subject to the questions that you have. I actually think I can get that done in about an hour. And then I have, although it seems like a lot on the outline, share, distribution, future implementation, and timing, I think all that together can be wrapped up in an hour as well. So I'm hoping that we will finish before the midday break.
Thank you.
So what would have, to ground ourselves again, the question we're asking is, what would have happened in a non-breach world? What reasonably and realistically was likely to have happened in the non-breach world based on the available evidence? And specifically, what would the First Nations have realistically done if they had received their augmented annuities when they were due? We don't know, Justice Hennessy. We can only speculate with reference to the available evidence. And the other day I summarized the sources of those evidence, which I won't go through again. In some cases, such as whitefish, it's clear where money, in that case for timber sales, would have gone if it had been earned. The Indian Act, in the whitefish case, for example, specifically provided that 90% of the timber revenues would be held in the band trust account. 10% would be paid out to the band. In this case, which is concerned with annuities, we don't know where the money would have gone, but the parties have proposed a few possibilities. In the past, annuities under this treaty and most treaties were paid directly to individuals. We agree with the plaintiffs that annuities are not considered Indian monies because they are not held on behalf of the First Nations. My friend, Mr. Schachter, took you to the Beatty case, and we agree with that. I can give you the site again if you need it.
Thank you.
Since they are not Indian monies, they are and were not statutorily required to be held in the band trust accounts, and they have not typically been held in the band trust accounts, except, as Your Honor noted, with the possible exception of some historical amounts that were not collected in a certain year. And I just also want to remind the court that although we have used the word invested as though money is invested in the band trust account, what really should be kept in mind is that the Crown keeps its money in the Consolidated Revenue Fund and creates a notional account for the band monies and credits that account with interest at the band trust account rate, which until 1969 was a higher rate than the regular short-term or long-term government bond rates offered to everyone else. So one possible assumption is that the whole amount of the augmented annuities might have been paid out to individuals. The reasons we might assume that are that that's how annuities were always paid out in the past, to individuals. Secondly, it's possible that individuals would have expected that because that was the history and the historical practice. On the other hand, this court has determined that the treaty promise requires the annuities to be paid to the First Nations collectively. So it's also a possible assumption that the annuities, the whole of the annuities, would have been paid out to the chiefs.
What about the limiting words of the promise with respect to individual distribution?
That, in that situation, which is what I'm describing now, is where the whole of the annuities would have been paid to the chiefs with the Crown's expectation that the chiefs would use them and or share them among the members of the band. And in fact, the way the treaty is structured, the Crown has some role in that, in determining what portion goes to the individuals. But generally speaking, as the idea would be, as a collective annuity, it gets paid to the chiefs to then determine how they want to spend it, collectively or distribute more to individuals, for example. So this idea that rather than the Crown having paid the increased annuities directly to individuals, that instead perhaps the Crown would have paid at least a large part of them to the chiefs because it represents the collective amount. If that were the case, It seems, I would suggest on the evidence, less likely that this is what would have happened for a few reasons.
So I just want to make sure that I have this. This is your first possible scenario, and it is that the whole of the annuity is paid to the chiefs.
I'm sorry, Justice Hennessy, I haven't been clear about that. No, I have two possibilities here. The first is that the Crown would pay the annuities directly out to the individuals.
Okay,
And I've said that may have been the expectation, that was the historical practice, but that's probably unlikely because of the collective nature of the promise. Again, this is just speculation. The second option is that most of the money, and I did say the whole amount, but I do acknowledge that the idea would be that most of the money would be paid to the chiefs as representing the collective, and then some portion, some smaller portion would be distributed to individuals.
so
But
first assumption, paid to individuals. Second, to chiefs.
that's the way I have
Thank you.
conceived of it, but I do acknowledge that even in the second scenario, if it's paid to the chiefs, some portion will be distributed to individuals, perhaps a very limited portion.
Okay.
And so that's a possible option, but I would suggest that it seems less likely, not just in view of the historical practice and perhaps the expectation of individuals that they would receive the money straight from the Crown. But I also would suggest on the evidence that it's less likely that the money would have been paid almost entirely to the chiefs, because we know the Crown was concerned about how monies would be spent or invested by First Nations generally throughout a lot of the time period. So really the third option, which is implicit, but I should make it explicit, is that the Crown would hold and manage the monies. And now this as well is speculation, because as I've acknowledged, these are annuities, and annuities are not and were not typically held in band trust accounts. That is, they are not and were not managed by the Crown on behalf of First Nations. They were paid directly to the First Nations. But I'm suggesting here, if we were to go back and think what likely would have happened if there was a significant amount of money representing a share of resource revenues, I'm suggesting it's quite possible that the Crown would have held that money on behalf of the First Nations. Rather than paying it out to individuals, because it was really a collective promise, rather than paying it out to the chiefs and expecting them to decide what to do with it. And the reason I say that is because the history shows that the Crown was concerned about how monies would have been spent or invested by First Nations at the time. And today we may consider that a paternalistic attitude, but the history shows that in fact was the case. The Crown was concerned about how First Nations were spending and investing money, or how money would be invested. And so I'll give you the example. For example, we know in the stage 1 decision, this court found that the $4 soft cap on the distributive amount was motivated by a paternalistic concern about how it would be spent. Your decision in stage 1 referred to the Colburn policy, for example, at page 454 of the stage 1 judgment. And Dr. Angel?
Can I just ask here? The concern about how money would have been spent or invested was a concern arising from distribution to individuals, was it not?
In the case of the Colburn policy, it was, yes.
Okay.
And I'm moving on now to this more collective concern, which was addressed by Dr. Angel and also discussed by Dr. Booth. They explained how in 1859, the government of the province of Canada was concerned about losses suffered by First Nations when First Nations invested their money in the stock market. And this gets us to this Six Nations situation. So I'd like to pull up Dr. Angel's report where he discusses this. Dr. Angel's report is Exhibit 87. And at paragraphs 40 and 41, he discusses a report of the Minister of Finance to the Executive Council of the Province of Canada in 1859. This, of course, was pre-Confederation. We'll have that on the board in a minute. So Dr. Angel, I think we have been through this before, Justice Hennessy, so you may recall it. I'll sort of skip to the highlights. Dr. Angel notes that as the current system, that is the system in place as of 1859, involved the possibility of a loss to the funds being invested because of worthless securities or stocks, the investment should perhaps be assumed by the province of Canada. This was really the genesis of the band trust account system. And Dr. Angel quotes from an 1859 submission prepared by the Minister of Finance with reference to a submission by Sir John A. Macdonald, who was at the time Superintendent of Indian Affairs. In paragraph 41, the minister further elaborated on why the government might want to secure the Indian Trust Fund. And this, I'm going to read from the quote from this report from 1859. The report noted that it would be desirable so to secure the fund as to prevent the possibility of any failure in the payment of the annual sums required for the Indians. Now, these annual sums are not referring to annuities, they're referring to interest payments. We'll see. So there's concern about preventing the possibility of any failure in the payment of the annual sums required for the Indians, as such failure would certainly be attributed to a breach of faith on the part of the government and could never be explained to the satisfaction of the tribes. By maintaining the present system of investment, it might also result that one tribe would find its annual interest regularly paid, while others would meet with disappointment. So the concerns expressed here, and as I said today,
These days, wouldn't we call that a defensive position? They're saying, well, they might blame us.
I think that's true, but I think it goes beyond that, and we should not assume that exclusively negative interest or concern on the part of the Superintendent General of Indian Affairs. We shouldn't assume that the only concern was protecting the government. There's a note right here about one tribe finding its annual interest regularly paid, while others meeting with disappointment. I don't think we should read this exclusively as though it's in the interest of the government. I suggest the government is expressing a concern here about the loss of funds. Yes, they acknowledge we'll be blamed for it, but that's not the only factor here that motivates the creation of the band trust accounts. The concerns expressed here were that the results of investments in the market were uncertain. Secondly, that the bands would not trust the government if they were told, don't worry, wait it out. These are long-term investments. In the end, it's going to be fine. And I suggest you can infer that from this point that the government is concerned that they won't be able to explain the loss. It will be seen as a breach of faith on the part of the government. And here I think the government is acknowledging that the First Nations aren't going to trust us if we just tell them, don't worry, you lost all your money. Stick with it. In the long term, it'll all work out. The third concern is there was a concern about inequity between the bands if some did better than others. So for these reasons, the government determined that it would protect the First Nations money by holding it in trust for the First Nations and crediting the bands with a guaranteed rate of return that was consistent with its own borrowing rate. And Professor Booth explained that this borrowing rate was considered high at the time because it reflected, as Canada's borrowing rate, it reflected Canada's risk as a young nation. It was a relatively high risk because of the risk of default. Canada had to spend a lot of money in order to borrow because of the risk of default, and it used that same high default rate, interest rate, to pay out on the band trust accounts. And this is why Dr. Booth explained that the band trust account rate was actually a relatively high rate. In fact, he went further than that. He called it almost a junk bond rate. You can see his report, Exhibit 29, paragraph 45 and following. And I noted before, Justice Hennessy, the reasons for the Crown having taken over control of First Nation funds may today be seen as paternalistic or disrespectful. But the fact is that up until at least 1951, when there were changes to the Indian Act that were described by Dr. Angel, that is how the Crown managed band funds. That is realistically what the history shows. Now, I suggest that augmented annuities, if paid to the bands rather than to individuals directly, and of course, I acknowledge some portion may have been paid to individuals directly. There was a habit of that, meeting at the Hudson's Bay Post or whatever to receive a portion. But if the majority of the increased annuities were to be paid to the chiefs, I'm suggesting the history suggests it's most realistic that the government would have actually held that money on behalf of the bands and credit it with the band trust account rate.
Isn't the weakness of these assumptions that they're assumptions that are based on a further assumption that the parties weren't engaged in any discussion?
Yes, I think that's true.
Because if there was some history of large sums of money coming in as the years went by, and levels of sophistication arose and engagement with the world developed, that there would have been a discussion. What? They're in a band trust accounts? We can't access, we can't make those decisions? Isn't that a problem with your assumption, not perhaps for the first decade, but for subsequent decades?
Absolutely, it is, Justice Hennessy. And I should make it clear that I'm only suggesting these as possible alternatives. We do not know what actually would have happened. And this gets into what Ms. Cruz's argument before. How certain do you have to be about what the non-breach world would have looked like? And I readily admit, we don't really know what the non-breach world would have looked like. The best we can do is consider possibilities based on the evidence we have. And I'm not suggesting to you, Justice Hennessy, that the Crown would have held all the money in the band trust account rate. I'm not telling you that that's what the Crown would have done. I'm just suggesting that's an option to consider, as well as considering the options that the money would have been paid out completely to individuals, or that the money would have been paid out completely to the bands, and the chiefs having free reign to do whatever they wanted with the money. We went through that, and I suggested that on the evidence, I suggest it's unlikely that the Crown would have agreed with that method, knowing as we do the motivations behind creating band trust accounts in the first place.
Thank you.
And I note as well, Justice Hennessy, I noted that certainly in today's world, and really after 1951, when bands were given more control over the management of their funds, we may view these policies as paternalistic. But remember, this action is not for the purpose of addressing unfairness in the Indian Act or the band trust account system. That may be another complaint for another day. The loss here must arise from the breach of the failure to pay augmented annuities. Considering where those annuities likely would have been invested, the loss here does not arise from failures in Crown policy for the management of band funds. So, summarizing these possible options, if all annuities were paid to individuals, they would not have been able to access the preferable rate offered through the band trust account. So, the long-term government bond rate is probably an appropriate rate to consider in that scenario. The long-term bond rate being a safe and theoretically available rate, unlike the band trust account rate that was only available to bands, not individuals. So the other option we discussed is if the whole amount.
Sorry, but you have said that's the least likely.
I think I'm not going to say it's the least likely, Justice Hennessy. I think it's unlikely.
Okay.
But I'm not going to say that it's less likely than the idea that the money would have been paid entirely or almost entirely to the chiefs.
Okay, those two you say are equal.
Yes.
Thank you.
And of course, what I do say is if it had been paid to the chiefs as a collective amount, if that had happened, in that case, I think it would be likely that the money would have been held in the band trust account and credited with the band trust account rate. So scenario one is individuals, long-term bond rate. And again, this is speculation. Scenario two is paid to the chiefs, likely band trust account rate. And I would also submit that in these circumstances, it's also a fair operating assumption that some portion would have gone into the band trust account rate and some portion would have been paid to the bands and or individuals. That's a possible option. And this is the option that is consistent with the Booth-Kersner approach. Professors Booth and Kersner took the approach that some of the funds would have been retained in the band trust account and some would have been paid out to the bands and further distributed to individuals. So I've gone through all of these possible scenarios. And the one that I've skipped is that the bands would have invested their money in a portfolio of stocks and bonds. This is the 60-40 proposition. In my submissions, the bands investing the whole or even most of the augmented annuities in a 60-40 portfolio of stocks and bonds and never withdrawing it, but just letting it accumulate compound interest year over year is not a realistic scenario. And here are some of the reasons. The bands were relatively small communities living in relatively remote areas. We've been through this without ready access to markets or advisors, without access at all up until 1951 as a result of the Indian Act and the Crown's management of funds, Indian funds. So for that, that's my first reason, that 60-40 investment is unrealistic. Secondly, I suggest the chiefs would have been under pressure to pay at least a portion of the annuities to the individuals. Evidence was that payments were made to, that first of all, annuities were paid to individuals, and there was probably a level of expectation that individuals would receive them. So the idea that the whole amount of the augmented annuities would have been invested by the bands in a 60-40 portfolio is unrealistic for that reason as well. It doesn't account for the fact that some money would have gone or needed to be available for individuals. That gets me to the third reason why the 60-40 portfolio is unrealistic. The chiefs would have needed the funds to be sufficiently liquid that they could address special concerns. The idea that the money would have been invested over the long term in 60-40 and not touched but allowed to accumulate interest is unrealistic, because over time, it's realistic to expect that the funds would have needed to be accessed for special concerns. This brings us to the risk point. It would have been too risky to tie up all of the band's increased annuities in long-term stocks and bonds. The first point being because of the liquidity problem. The second point, the uncertainty of the returns. And finally, continuing on the idea of risk, it is unlikely that these Robinson Superior Treaty bands would have trusted leaving all of their money with investment advisors, likely in New York or London. And the reason I suggest that you make that finding, or where that finding I think is implied in the evidence, is that the First Nations had no basis on which to believe that leaving their money in markets with investors would end up over the long term to be the best place to put it. The reasons that the First Nations would have had no reason to believe that applies to everyone. As Professor Booth described, this is the nature of risk. It's fine now in hindsight to say it's been best to leave your money in the markets over the long term. People didn't know that and couldn't have known that back in the day. And so there's no evidence that these First Nations would have been willing to take the risk that they would give all of their money to stock and investment advisors and just trust that it was going to be taken care of. And in this respect, I think it's interesting that in that 1859 report prepared by Sir John A. Macdonald, it was noted that government officials were concerned that the bands would consider a loss a breach of faith on the part of the Crown, which suggests, I submit, Justice Hennessy, that there was a trust concern here, in the sense that there wasn't evidence that the First Nations would have been trusting of government officials and quite possibly of investment advisors. I want to address two cases in which, well, first, actually, I want to address the question I didn't get to yet about the question you asked the other day about what about the evidence of portfolio investments of Six Nations in Michipicoten. Just very briefly, with respect to Six Nations, the evidence was very limited, and it was without any context, Justice Hennessy. We don't have any context about those limited statements that were presented in evidence. We don't know how they fit in with the broader picture about what Six Nations was doing over a longer time frame, or why they were doing what they were doing, or what kind of advice they were being given. But the main point to take away from the Six Nations experience is that Six Nations lost much of their investments, and that was the motivating, or a motivating factor behind the creation of the band trust account system. I didn't go through that quote, but when you look at the quote in Dr. Angel's report, it's specifically mentioned at the loss in the Grand River Navigation Company. With respect to Michipicoten, I would just advise that Dr. Angel provided evidence that in 1865, the government invested in a debenture in the Consolidated Municipal Fund for Michipicoten. This was also very limited evidence. I don't believe we had an explanation as to why that particular investment was made at the time, but it's one limited example. Furthermore, Chief Tangi testified that from 2008 to 2012, Michipicoten was investing in 100% fixed income, that is bonds, and only began investing 60% in equities in 2017. And again, that's very limited evidence. And I will defer any further questions about that evidence to Council for Ontario. But I would like to refer the court to two cases which have examined investment options for First Nations funds and which have noted the benefits of the band trust account rate approach and found that in those cases where the Crown owed a fiduciary duty, the Crown's fiduciary duty did not require investment in diversified portfolios, but was met by the use of the band trust account. The two cases I want to draw up are Ermineskin and Southwind. So taking a look at Ermineskin in particular, this is a decision of the Supreme Court in 2009. This concerned the Crown having collected oil and gas royalties in respect of deposits on the Sampson and Ermineskin reserves and holding those royalties in the band trust account, that is, crediting those royalties with the band trust account rate. The First Nations sued with the argument that the Crown breached its fiduciary duty by failing to invest the royalties in a diversified portfolio. You may recall that, in fact, Professor Booth acted for the First Nations in that case. The Supreme Court held that the Crown did not breach its fiduciary duty, that fiduciary duty did not require investing in a diversified portfolio.
Did Professor Booth act for or?
I'm sorry, did I say act for? I should have said was retained on behalf of. The Supreme Court in that case cited the same passage from 1859 that we saw in the Angel Report that's cited in the Ermineskin case. And I want to look at paragraphs 191 and 192, which are up on the board. It was argued that the inability of the Crown to invest resulted in lower returns than those available to non-Indians, and that this amounted to a disadvantage to the bands. In purely financial terms, it is not readily apparent that precluding investment by the Crown necessarily amounts to a disadvantage. It is true that interest calculated on the basis of the yield on long-term government bonds adjusted quarterly will, in most cases, over the long term, lead to lower returns than might accrue through a diversified investment plan. That said, holding the funds in the CRF, Consolidated Revenue Fund, and paying a return in accordance with Section 61(2), which is the Indian Act Band Trust Account rate, ensured the liquidity of the funds, such that all funds in the band's accounts were available for expenditure at any time. In addition, there was no risk of loss of the band's royalties. It is misleading to gauge disadvantage solely on the basis of comparative returns. Risk and liquidity are also relevant considerations. The second case I'd like to refer you to is the Southwind case, and here we'll look at the trial decision at paragraphs 498 and 499. Here, the trial judge adopted the position taken by experts who had been retained on behalf of Ontario and found that the appropriate way to assess present value was to assess it using the band trust account rate. The trial judge, this was Justice Zinn in the federal court, noted, "I agree with Mr. Prisman, the expert on behalf of Ontario, that the most realistic vehicle for determining return on money is the annual Indian trust account rates set by Canada. As he testified, why would they go to an investment that might be a risky investment, when they have a risk-free vehicle, the Indian trust account, that does not suffer from default risk? It's backed by the government. It may be that the band would have invested in a high-performing stock, IBM or Google, but it is equally possible that it would have invested in Bre-X or Nortel and lost most of its capital. I'd like to turn to the Booth-Kersner model. There may have been problems with the Booth-Kersner model, and Professor Booth may have been a combative witness in cross-examination. But he is still one of the leading finance experts in Canada, and he has something to tell us about how people invest and what kinds of returns they can get. Mr. Schachter argued that if a person spends money on a particular consumable at a point in time, the value of that consumable must be considered to be greater than what the person could have received if they had invested the money. Realistically, people do not think that way. They do not make those kinds of calculations. Realistically, people spend money to acquire the things they need in the moment, and if they are lucky, to acquire the things they want. Professor Booth,
This proposition comes from,
Professor Booth's report.
realistically, people spend money to acquire things they need in the moment and are lucky enough to acquire things they want.
Lucky enough to acquire things they want is my added portion, but Dr. Booth talks about the purpose of money being to consume.
There are whole communities that don't adopt this. I won't identify them, but there are whole communities that for whom this proposition would be contrary to every fiber of their being.
And I accept that, Justice Hennessy. When we're talking about these kinds of issues, we have to be talking about, again, we don't know the actual evidence of how people would have acted, but we need to consider the evidence we do have about patterns of behavior, for example. And all I'm suggesting is that we'll go through what Professors Booth and Kersner have to say, and you may find some help in it or you may not. But what Professor Booth has told us is that very few people actually invest in stocks, and people often don't hold on to long-term bonds. They get nervous and sell early. And I acknowledge that this doesn't necessarily apply to the whole population, in part because most of the population doesn't invest at all, according to, I'm taking that from Professor Booth's point, that very few people actually invest in the market. So I realize where some of these principles may not be universally applicable, but I think they're worth considering. Remembering, of course, that Professors Booth and Kersner developed their approach based on guidance from the Ontario Court of Appeal in Whitefish. And Professor Booth made this absolutely clear in his oral testimony. They were asked when they were retained by the Department of Justice back after the Whitefish decision, what do we make of this? How could we do this? That was at Professor Booth's transcript, page 3816. So we'll just look briefly at the Whitefish case. I know, Justice Hennessy, that you're already familiar with it. I'm conscious of the time, but I think we can get through Whitefish in the next few minutes. The Ontario Court of Appeal expressed discomfort, as I've said, with the idea that 100% of the funds that actually were held in the band trust account in that case would have attracted the band trust account rate compounded over 120 years. Now recall in Whitefish, the proceeds of the timber sales pursuant to the Indian Act were to be paid out 10% to the band to be spent as the band might choose, and 90% held in the band trust account rate. And interestingly, the Court of Appeal only concerned itself in its decision with what would have happened with the 90% and didn't address if and how the 10% might be assessed in present value. But as for the 90%, the Court of Appeal told us, and here I would like to go to look at some paragraphs of the Whitefish case, starting at paragraph 103. In paragraph 102, the Court of Appeal discusses the argument of dissipation, an argument that had been made by the Crown that the money would have been dissipated. And in paragraph 103, the Court of Appeal says that, or paragraph 102, the Court of Appeal says, I disagree, that we can't assume the money would have been dissipated. And goes on to say in paragraph 103, and I will paraphrase for the sake of time, this does not mean that Whitefish is entitled to 120 years of accumulated capital and interest. That, too, is unsupportable. And the Court of Appeal goes on to say, what we need to do is apply realistic contingencies. And I acknowledge in the case law and in my friend's argument that there are differences of opinion as to what realistic contingencies might be. But we have this Ontario Court of Appeal decision that's worth looking at and considering. The next paragraph I'd like to look at is paragraph 110. Here, the Court of Appeal is telling us, in fixing Whitefish's award of equitable compensation, that case was a fiduciary case, unlike ours. I think it quite appropriate to take into account that over the years, the band would have spent at least some of the interest earned on its capital investment, and perhaps even some of the capital itself. The figure there is represents 90% of the court's determination that the timber rights would have been sold for $31,600. That's 90% there. And in paragraphs 115 to 117, I'm looking right now at paragraph 116. If Whitefish is to be restored to the position it likely would have been in but for the breach, then the question whether Whitefish would have spent the money it ought to have received and how it would have spent the money need to be addressed. And the court goes on to say in paragraph 117, what is needed is evidence either from the Whitefish trust account records or elsewhere showing Whitefish's actual spending patterns over the period. So this is the genesis of the Booth-Kersner approach. I mention it for two reasons. One, this is the Court of Appeal's direction on the kinds of consideration that the court should have when they're constructing what realistically and reasonably would have happened in a non-breach world. This is what the Court of Appeal tells us. But secondly, I'm drawing it to the court's attention to help emphasize that this is what grounded the Booth-Kersner report. And we had a lot of criticism of Booth and Kersner, and I guess what I'm trying to do really is to some degree salvage the work that they did, which I, once we return from the break, will submit is actually quite helpful. Even if you don't adopt the whole approach, there are some very helpful elements, and it does provide at least some evidence that we don't have in any other place. Would now be an appropriate time for a break?
Yes, thank you.
I have one last bit that I'd like to put on the record here, which is that it is Mr. Bass's birthday, and we wish him happy birthday.
Well, thank you for that. And best wishes from all of us in the room, Mr. Bass. Okay, let's take the break and let's just go off the record for a second, please.
Order, all rise.
This court is resumed. Please be seated.
Justice Hennessy, we left off just about to get into the Booth-Kersner model, keeping in mind that the intention was to examine realistically how these First Nations spent their money, because it may be a guide as to determine how it might have been spent in the non-breach world. Professors Booth and Kersner, of course, acknowledged that spending patterns will change with more money. Typically, there will be more saving, but already these bands on the Booth-Kersner model are saving a lot, roughly 50%. So I'd like to pull up Exhibit 42, which is that figure, the sort of chart. And I should have had my own copy because it's so hard to read here on the screen, but you're familiar with it. And I think it sets out in a nice summary form what the conclusions of Professors Booth and Kersner were from their analysis of the band trust account statements. And I should note, my friend, Mr. Schachter, said that neither Red Rock nor White Sand were considered. That's not in fact correct. Red Rock was one of the bands for which we had data. White Sand, there was no data for White Sand until starting in 1929, so it was felt it wasn't one of the most representative bands to use, but Red Rock is in there in the analysis. In fact, half of the bands, 3 from the group of 5 and 3 from the group of 7, were in the data set. And Professors Booth and Kersner determined from that set that, again, they took this approach. Maybe the money would have gone in all 3 places. Some kept in the band trust account, some paid out to the chiefs on behalf of the bands, and from that, some paid out to individuals. And so you can see, notably, the part that would have stayed in the band trust accounts based on the band's historic saving patterns and earning the band trust account rate for the reasons we've discussed, that 1859 policy, is almost 50%. And of the other 50%, that was in fact spent on some things for the bands as a collective and some for individuals. So this model takes into account all of these possible considerations. And they use their expertise as finance scholars to assign appropriate rates of return to the various categories of spending. We should keep in mind their evidence that these were what are called real rates of return, which means that when you actually apply them in any given year, you need to increase them to account for inflation. The reason they use these real rates of return is because the real rates are constant, whereas every year inflation changes. So in every year, when they applied these rates, they used a slightly different rate depending on what inflation was. And they told us they never let inflation go below 1%. Even though in actual fact, there were some years where inflation was negative. Now, I noted that these real rates of return would be increased to account for inflation. They were also then, some of them anyway, decreased to account for depreciation. Depreciation accounts for the fact that when you spend money on an item like building a community center, you also have to spend money keeping it up. The value of the community center and the value of all the money spent on keeping it up cannot both continue to increase through compound interest, because the money spent on the upkeep is necessary to maintain the value of the original asset so that its value can continue to increase every year. I submit, Justice Hennessy, that this consideration of depreciation was an important element of Professor Booth and Kersner's approach. And it it injects realism into the calculation or estimate. And I think this is important because it is responsive to the Court of Appeal in Whitefish. The Court of Appeal was uncomfortable with the idea of 100% compounding, saying it's just not realistic. And the duty here is to determine what realistically would have been done in the non-breach world, keeping in mind that Whitefish was a fiduciary duty case. And the duty here is the duty of diligent treaty implementation, where imperfection is noted. The Crown is required to seek and endeavor to do its best. I wanted to address, my friend had mentioned, and you'd questioned about the 93% savings rate. And I've just shown you on the exhibit 42, Professors Booth and Kersner noted, first of all, 50%, roughly 50% on saving in the band trust account. But they also note that of the portion paid or distributed, transferred to individuals, some of that would have been saved as well. So where the 93% figure comes from was, if I recall correctly, it was a point made in cross-examination that Professors Booth and Kersner looked only at the revenue account, which is, you might remember from Dr. Angel's testimony, band trust funds are held in the capital account, and then the interest generated in the capital account is put into the revenue account, and that's where the money is spent from, is the revenue account. And ideally, you do not deplete the capital account, because if you do, it's going to affect the interest that it will generate for spending in the revenue account. So the capital account, the intention in the capital account is that you don't touch that money.
So the 93% was from what was in the capital account. 93% was saved.
My understanding is, was actually a combination. If you look at the capital and the revenue account, the total saving was 93%, is how I understood my friend's calculation. But it was certainly not the evidence of Professors Booth and Kersner, for example, that the savings rate was 93%. My point being that the money in the capital account is expected to be saved. So it's not helpful to note that, in fact, look how much money was saved in the capital account. That was what the capital account was for. That's how it was intended. You asked, effectively, why haven't Professors Booth and Kersner backed down from this approach since the criticisms of it by Justice in Southwind and in the specific claims tribunal? You asked that the other day. And there are two answers to that. The first is that they have responded to the criticisms. The model they used in this case has been modified to take account of those criticisms. Most notably, one of the main criticisms was that Professors Booth and Kersner originally did not apply any rate of return to consumption. Effectively, they treated it as the Ontario Court of Appeal appears to have treated the 10% in Whitefish. But in this case, which is that it wasn't considered to be necessary to bring that forward to present value. But in this case, Professors Booth and Kersner, in responding to that criticism, assigned a rate of inflation for consumption to at least ensure that an item that you would have consumed of short-term value, an item of consumption, you would still have the money, that same amount of money to theoretically consume that same item in the future. And second, the first point being that they this model used in this case attempts to respond to criticisms. The second point being, as I made earlier in my submissions, the specific claims tribunal is intended as a simplified process. It has a statutory limit of $150 million. In the Huayat case, the total award, Huayat, I think it's spelled HUU-AY. Okay, great. I'm going from memory. And of course, the simplicity of the band trust account rate was seized upon by Justice Zinn in Southwind. And we looked at those paragraphs where he adopted the Prisman model, the Lazar-Prisman model, partly, in fact, largely because the band trust account approach was just simple. So the concern was that the Booth-Kersner approach was complex and time-consuming, and those were factors against its use. In my submission, the Booth-Kersner approach is really not that complex. Yes, it is time-consuming to do the analysis and prepare the figures. There's no doubt about that. It's time-consuming and tedious to go through the trust accounts and prepare the calculations. It's time-consuming. But this case warrants the time spent. It's been spent and it was warranted. As for complexity, I submit it's not really that complex. When you look at that chart, Exhibit 42, it's pretty straightforward to understand what they're doing. I'd like to then move to
The categorization of expenses that's complex, is it not? Or is it the disagreements that may arise from individual labeling of every expense and the judgments that it makes, or the lack of information that is available? Is that not what the complexity is? Or does that go to reliability?
Yeah, I don't know whether that really makes it complex. I think maybe reliability is the right point. It reminds me of the debate in this case between what expenses should and shouldn't be deducted from from Crown resource revenues. It's a judgment call. People may look at the expenses and reach different conclusions. Professors Booth and Kersner acknowledged that sometimes the data in the trust accounts isn't very detailed. And in fact, they've told us that they attempted to take a generous view, for example, in categorizing some spending as social investment rather than as consumption. They tell us that they deliberately took a liberal view of social investment, for example. So yeah, there's a lot of judgment required in it. I don't think that necessarily makes it unwieldy or far too complex. So ultimately then I want to look at the various rates of return, the average rates of return that are generated by the various approaches that were proposed by the experts for assessing present value. And for that, it's handy to look at Exhibit 40, which was the slide deck from Professor Kersner's evidence. And at slide 32, on the left-hand column, we have a list of the average annual rates of return that were derived from the various models. The 4% they just use as a comparator, because this slide was actually discussing how multipliers work, which I'm not going to get into today, but that you should disregard that part of this slide because it's a complex issue that we don't need to get into now. What we're really looking at is the left-hand column, and you'll see Professors Booth and Kersner, you may recall, had 4 different models because they acknowledged that one might consider saving and spending by the individuals, and that was only like for roughly 20% of the spending. That you might consider the typical pattern we see in Canada is 80% consumption, 20% savings, generally speaking. So they use that model, but then they also assumed if we really broaden the category of what is considered saving or investment, let's say it's 35% rather than 20, they use that model. And then they capped inflation. And so in their different models, so they arrive at a models ranging from 4.35% to 4.66%. This compares with the long-term bond rate, which we've heard of, 5.01%. Band trust account rate, you see it there, 5.316. And the Hutchings-Stiglitz rate, 7.2%. And I should note, these are just the averages. In fact, as we've discussed before, in every year, you actually apply a different rate.
Can you please remind me, Model 1 and Model 4, what were those savings rates? Was one 20% and 4 35%? Or do you know?
Yeah, that's going to take me a minute. I'm going to get my colleagues to pull up again. If I recall correctly, there was a chart that showed the 4 different models.
Yes.
And I'll ask my colleagues to find that for me. But I do know that the variability was based on 80%, 20% saving versus 35%, 65% saving. And that's not what I'm looking for. And whether inflation was capped at 5% on the high side or uncapped, I believe. I'll have my colleagues pull that up. And
Could you please go back to the screen before so I could get something from that?
which would be slide 32.
Thank you. Thank you.
While my colleagues are looking that up, I wanted to address my friend's argument that the long-term bond rate of 5.01% would be insufficient because it barely covers inflation. And you may remember Mr. Schachter. Oh, and I'm going to interrupt myself to answer your earlier question, Justice Hennessy. I'd ask that my colleague put on the board slide. Which slide is this? Slide 36 from that, 56 from that exhibit 40. And here you see the factors that went into the creation of those 4 models.
So Model 1 was 20% saving.
That's right, with inflation capped at 5% on the upside. The reason that Professors Booth and Kersner capped inflation was to account for unusual circumstances to smooth it effectively. But then as an alternative, they prepared models 3 and 4 that were not capped at all for inflation on the upside. But in all 4 models, they capped inflation at a minimum of 1% on the downside. They never let it go below 1%, even though sometimes there was 0 or negative inflation. Again, we said that was slide 56. Thank you very much.
Thank you.
So then moving back to my friend's argument that I wanted to address, wherein Mr. Schachter suggested the problem, or one of the many problems he suggested with the long-term bond rate, is that 5.01% is barely more than the average rate of inflation. So first of all, I'll note that in that chart we looked at Exhibit 42, it was indicated that over the long time frame, the average rate of inflation was 3.57%. That actually covers the time period 1876 to 2020. But Professor Booth's evidence in the Booth report, Professor Booth also used a figure of 2.95% for a different time period where he was discussing a certain set of figures. That time period was 1924 to 2021. And I just wanted to note that in case your honor at all becomes confused about what is the average? Is it 3.57 or is it 2.95? Both figures were used, but it's because it depended on the time frame used. And I should note that this discrepancy in those figures was explained by Professor Booth in the transcript at page 3949. But let's assume, we'll take my friend's hypothetical or calculation where he said, if we take the long-term bond rate at 5.01% and we subtract out the average rate of inflation at 3.57%, then the real rate is really only 1.44%. The First Nations are really only receiving interest of 1.44% is how I took Mr. Schachter's argument. And my response to that is twofold. The first place I want to take you is to the Bank of America case. Bank of America versus Mutual Trust, which is a 2002 decision of the Supreme Court, which discusses compound interest in particular and explains the time value of money. This won't be new to you because we have discussed it before. I think my friend referred to it. But I wanted to note that here the Supreme Court explains three factors that account for the depreciation of the value of money over time. One is opportunity cost, which the Supreme Court characterizes as, and here I'm reading from paragraph 22 of Bank of America, opportunity cost reflects the uses of the dollar which are foregone while waiting for it. The second component is risk. And in paragraph 22, the Supreme Court characterizes risk as reflecting the uncertainty inherent in delaying possession. So it's the uncertainty that's being addressed. And then third is inflation. Inflation, in fact, I think is a complex phenomenon. I'm not sure we really got an explanation from anyone exactly why it occurs. But in any event, it's something we can understand as lay people. We experience inflation. But I'm looking at so Mr. Schachter said, if you take the 5.01% and you back out 3.57, which reflects inflation, the 1.44% is doing all of the work to account for the lost opportunity and the risk. In that example, Justice Hennessy, I submit there is very little risk, in fact, because we're talking about a government bond rate, which is guaranteed by the government. There is actually no risk of delaying payment. Now, it's the case that the First Nations have had to wait these 170 years. But as long as their right is legally enforceable in the court, their right will be vindicated in the sense that they don't need to worry about never seeing the money. As long as they have a right to it, they don't need to worry about never seeing it if it's guaranteed by the government. So I suggest this is consistent with what the experts told us, that there is very little or no risk rate. A risk-free rate of return, I think, is how Justice Zinn characterized it in Southwind in using the bond rate, a government bond. So really what we're looking at is 1.44% accounting, doing all the heavy lifting for the lost opportunity. And I would submit 1.44%, there's no evidence or reason to believe that 1.44% compounded annually is insufficient to deal with lost opportunity. And for this reason, I'd like to turn back to Exhibit 40 and look at slide 2.
So just let me make sure I understand this. 1.44 is the difference between the long-term bond rate and inflation?
That's right. The average long-term bond rate of 5.01 and the average inflation rate of 3.57. So when you take a look at Exhibit 40, slide 2, we see Professor Booth and Kersner's calculation of what the present value would be on the various different models that they use. And here they are using the experts' calculation of net crown resource revenues based on Professor or Mr. Hutchings' estimates of net crown resource revenues. So remember, we're looking at the plaintiff's figures brought forward to present value. And you see, we saw before that Model 1 is using a rate of 4.35%. And we know the long-term bond rate was 5.01. The band trust account rate, 5.316, I think. So really, let's compare Model 1, 4.35, and the bond trust account rate, 5.3. So they're both roughly 1% apart. And the difference here is well over $3 billion. 1% results in a difference of well over $3 billion. So I submit that we cannot conclude that 1.44% is inadequate to account for lost opportunity. We've seen how these even fractions of a percent have multi-billion-dollar implications over the time frame here.
I'm just going to catch up for a moment. Your last point is comparing models 1 at 4.35% with the BTA rate of 5.3%
Is
gives you a difference of $3 billion.
it would be the difference between, if we were to subtract, if we take 9,876 and subtract 5,436. And I'll ask one of my friends to do that for me. I didn't make that clear that I was actually asking. We're going to take 9,876, subtract 5,436.
You'll get 4.4.
And you get $4,440,000,000.
Right.
I think I'd said 3. I was doing it roughly, but
I said 4.4.
$4.4 billion. Thank you. And the final point on that, Justice Hennessy, is again getting to why should we assume that 5.01% isn't sufficient when, according to Mr. Schachter, the real rate really only amounts to 1.44%. Why should we assume that's not sufficient when we know that 5.1% represents what people can actually get in the marketplace and could actually get in the marketplace if, like most of us, they are cautious, inexperienced investors, or people without access to sophisticated investment advisors. Before I sum up Canada's submissions on the present value, I just want to make a correction to an error in my friend's submission. I want to look at the chart in Mr. Hutchings' reply report. It was Exhibit 4, page 56. Mr. Schachter used this in his compendium, which was marked as Exhibit II. And he suggested, or seemed to suggest, that if Professors Booth and Kersner had used higher rates of return for human capital, their figures would have reached close to the 7.2% that was used by Professor Stiglitz and Mr. Hutchings on the portfolio approach. And Mr. Schachter compared the yellow bar of the graph with the orange bar of the graph. But I just wanted to note, because I don't think it was clear in Mr. Schachter's submission, that these are cumulative effects. You can actually see in the chart the little plus signs on the legend in the left and the description of the chart in the actual report. The yellow bar represents the cumulative effect of 3 different things. First, correcting what Hutchings terms correcting the consumption, not just using the inflation rate that Booth and Kersner did, instead using the Hutchings bond rate, then removing the depreciation adjustment, and then adjusting the return on human capital from the one used by Professors Booth and Kersner, which we saw in Exhibit 42. Cumulatively, that results in the orange or the yellow bar. I just felt that it was necessary to correct that.
Thank you.
Finally, in summing up this part of my submissions, we've been speaking about and using the language of bring forward, which is the mathematical approach that the experts take. But your job is an assessment of present value, which is not necessarily mathematical. And Canada's position, as expressed in our written submissions, is that the net Crown resource revenues expressed in present value using the long-term bond rate is appropriate because the 60-40 approach is unrealistic. The band trust account rate doesn't account for the fact that the annuity amounts received by individuals would not and could not have been invested at the band trust account rate. That rate is a relatively favorable rate and is probably too high in the circumstances. The Booth-Kersner approach injects valuable realism into the analysis and takes into account the guidance of the Ontario Court of Appeal. So there are valid points to be taken from the Booth-Kersner approach, which results in a figure lower than the band trust account rate and even the long-term bond rate on average. And Canada's submission is that the figures you have, which compare net Crown resource revenues as calculated by the plaintiff's experts brought forward on the long-term bond rate, with net Crown resource revenues as calculated by Ontario's experts, the experts retained by Ontario, also calculated on the long-term bond rate. These are appropriate figures to use in your assessment because the long-term bond rate is a reasonable approach for assessing present value, having in mind these problems with the other alternatives.
And you say the single problem with the band trust account rate is that it was not available?
That's the main problem, and that is the problem that I articulated a moment ago. It wasn't available to individuals. But the other part of the problem, Justice Hennessy, I think, comes out of Professor Booth and Kersner's approach, which is that we need to take into account things like depreciation. And that really addresses the Ontario Court of Appeal's concern about 100% compounding. We need to take into account not everything realistically increases in value by compound interest at 100%. So that's another problem with the band trust account rate. That's the realism that the Booth-Kersner approach injects.
Thank you.
I'd like to move on to share. I don't have a lot to say about it, Justice Hennessy, because that is, I don't have much to supplement what we've already said in our written submissions. So I think it's possible we could cover it before the break. But it might make us go a few minutes late. So I can get started if you'd like.
Let me just check.
Sure.
What is the?
Yeah.
5 minutes. Oh, I'm sorry. No, I was assuming we typically break at 12:30. Shall I go ahead then?
Yes, please.
Okay. I'm not suggesting I'll be done share in 5 minutes, but it might be 10, but we'll be close enough.
Thank you.
So with respect to share, my friends suggest two possible options, 84%. And very clearly their backup of 58% is very clearly not their preferred approach. Their preferred approach is the 84%. I just have a few comments to make on that. It's incorrect to consider $10 as the buy outright price, since, as the points we make in our written submissions, $10 was offered for different lands. But more importantly, $10 under those treaties was all that was offered. Here, the annuities started out at $1.60 per person, but they were subject to augmentation in terms of the numbers of people paid and also in terms of the total amount paid. So they cannot be compared directly. You cannot do a direct comparison between $10 versus $1.60, and I think you have that point. The other point I'd make, Justice Hennessy, is if we were to follow that logic, that the Crown bought 16% of the land and resources outright, then I question why we are talking about sharing 100% of the resource revenues. On that logic, it would make more sense that the Crown should be obliged to share the remaining 84% of the net Crown resource revenues on the logic that they have bought outright 16%. In which case, the plaintiff's share, if you were to split the 84%, of course, half and half, would be 42%. I just raised that because I think that that's where the logic takes you if you have this idea that the Crown bought outright a 16% interest. That's not, in fact, what the treaty means. In the alternative, my friends suggest the 58%. And here I just want to explain, Justice Hennessy, where that number comes from, because I found, I thought it was a little bit unclear. It has been unclear in the evidence and I think in my friend's submission. So I just wanted to return to where that figure is explained in the evidence. And it's explained in the Hutchings report. Actually, no, I think it's the Hutchings-Stiglitz report, Exhibit 3. At paragraph 159. And in that paragraph, it's explained that using the standard Nash equilibrium suggests a 50-50 share of the surplus value. They suggest that the Anishinaabe are entitled to the total return on undeveloped land because they own the land. And the surplus above that requires the Crown and the Anishinaabe to split 50-50. So effectively what they're saying is that the First Nations get a 100% share of the undeveloped land because they own it and only need to share the developed land. And if that were shared 50-50 pursuant to the Nash bargaining model, that's where the 58% comes from. And that was Mr. Hutchings' report, Exhibit 3. I just wanted to explain it, where that figure comes from.
Thank you.
You will have seen from our written submissions, and we discussed it the first day of my submissions, that Canada suggests a share in the range of between 20 and 50%. 50% because there is some support in the evidence for this Nash bargaining approach. But in our submission, it's also realistic to take into consideration an approach that accounts for, of course, we're instructed by the Court of Appeal to look at the relative wealth and needs of the different communities. And in considering the relative wealth and needs, one possible consideration is their relative populations. And so the 20% proposal that we have put forward is based on an acknowledgement that the population of the First Nations today is roughly 10% of the total population. And of course, we acknowledge that that doesn't account for historic relative population or for differences in wealth and needs. But the point I want to make here, Justice Hennessy, is that not all differences in wealth and needs can be addressed by augmented annuities. And not all differences need to be addressed by augmented annuities. Because not all causes for the differences in wealth and needs can be traced to the failure to pay augmented annuities. We heard evidence about other reasons for differences in outcomes, like colonialism, colonial attitudes and policies, racism, residential schools. Many of those factors may have caused or contributed to differences in rates of labor force participation, and inadequate land bases have also been problems that will have contributed to the differences in wealth and needs. And we point out in our written submissions that many of these problems that have caused these differential outcomes are being addressed in other cases or through other means. All of the G7, the First Nations from the Group of Seven, for example, have outstanding claims for additional land. This was noted in the intervention orders. There was reference to their various claims. In considering this reality, we should be reminded of Justice McLaughlin's instruction in Canson that losses made good are only those which, on a common sense view of causation, were caused by the breach. And I made the point the other day in the overview that if the Crown shares resource revenues by giving 20% of the revenues to the First Nations, this does not mean that the other 80% is spent to the exclusion of benefits for the First Nations. It is spent on behalf of all citizens. And you raised 2 points. One was whether I was talking about the future, if I remember correctly. I'm talking about the past because here we're talking about compensation for the past. So I want to make it clear that what I'm suggesting is that in the past, if we were to now allocate 20%, a 20% share for the First Nations, that doesn't mean that they did not receive any benefit from the 80% share that was already spent. And your response to that was very clearly, well, then why do we have such a large income gap? It would appear from the income and wealth gap that the First Nations didn't benefit from that 80%, is how I took your question. But we don't actually know that the failure to share in resource revenues in particular was the cause of the wealth and income gap. Sharing of resource revenues likely would have improved the wealth gap. But just as the wealth gap cannot be wholly attributable to the loss of a share of resource revenues, it cannot be fixed solely with increased annuities based on a share of resource revenues. Resource revenues are only one piece of the pie. The differential outcomes of the First Nations communities are not all attributable to failure to receive a share of resource revenues, and therefore cannot be remedied and should not be remedied in this case solely by augmented annuities.
I just catch up for a moment, please. Go ahead. Thank you.
I've actually got less than half an hour in my submissions, but I think it's probably appropriate time for a break.
All right. Mr. Greenberg, are you on? You don't have to turn on your screen if you don't want. No? Okay. Okay, we'll break then till 1:45. Quarter to 45.
1:45.
Can someone make sure they alert Mr. Greenberg? Thank you.
Order all rise.
Just,
This court is stood down until 1:45.